Look at this. 12 days before McDonald was settled, Jeffrey Mason filed an appeal against Judge Lynch's summary judgment 4.5 months after the journalist and the murderer ran in the New Yorker. Now, there's certain First Amendment rights here. Yes. The court said the law is unclear whether actual malice can be inferred solely from the proof that an author, by using quotation marks, ascribed to the plaintiff words that he did not speak. One of the three appeals court judges, Alex Kozinski, yes, sharply dissented, saying the right to deliberately alter quotations is not, in my view, a concomitant of free press. He proposed a five-step test for any disputed quotation. Does the quoted material purport to be a verbatim representation of what the speaker said? If so, is it inaccurate? If so, is the inaccuracy material? If so, is the inaccuracy defamatory? If so, is the inaccuracy a fabrication, or was it committed in a reckless disregard of the truth? Oh, this was like a First Amendment case in 1993? Yes. Why don't you get me every retired judge in the United States that's no longer sitting on the bench? I'm going to tell you, if you're still alive and you're a judge anywhere in this nation, I'm going to sue you and any of your deceased descendants right now. Because I know that there are judges that are alive at this very moment that are no longer practicing law. So get me all of them, every judge in the nation that happens to be alive, that think that it's not a crime, right, to use forgery and fraud, to be deceptive when motioning a court for dissolution of marriage, then finding out my sons are in the wrong grades, then they're in this little cold called away right now. See, I think that I should, right, be able to father them. And when I use a screen print of the Peninsula Daily News, was it an actual quote from the prosecuting attorney's office? Was it a quote? Is it admissible as evidence that you're refusing to admit exculpatory evidence that I wasn't in Sequim, Washington? Yeah. I wasn't in Brennan? Yes. And then when I tell you that I want you to do it, you seem to think that it is not admissible, but I think it is. Now, these newspapers that run articles about exactly what's going on, I think every time I use a screen print from a newspaper, that is exactly what's been said. Yes, that in a court of law, yeah, it is admissible. Now, I know you're sitting there as in, well, we do know about this Maryland versus Brady, or is it Brady? Now, what is your problem with enforcing the laws of the United States? Well, I sent you an email that the prosecuting attorney has personally said we had to do this because of Supreme Court decision. And then I send you millions of emails, yes, that and this is a forgery, yes, and issuing this is a fraud, poop. And then I send you emails that I wasn't in Sequim, but you would not admit the evidence. And then you had me recently arrested. Oh, now I didn't need to go to jail on the 23rd of February, did I? No, I didn't need to go to jail for a failure to appear in Brennan, Washington because of an arraignment that took place on August 28th. No, all you needed to do was to admit the evidence, and you would have saved me years and years and years of pain and suffering. I wasn't in Brennan on December 31st of 2015. Now, why is it, yes, that you do not realize the importance of what I'm telling you? Obviously, yes. When you arrested me in this library, right, not last Saturday, but the Saturday before, that was arrest that I didn't have to experience. Yes. And when you arrested me for the failure to appear, yes, in Brennan, Washington, that's something I didn't have to experience. Yes, because As it says in the Peninsula Daily News article, I was not in Sequim, Washington on December 31st. Now, Nichols said he was obligated to issue the January 25th notice under the U.S. Supreme Court case Brady versus Maryland. There was an obligation on the part of the prosecuting attorney's office. State criminal rules on discovery and rules of ethical conduct. Yes, yes. This ethical conduct on the part of attorneys. Yes. Well, let's look at it. I was in Port Angeles, Washington on December 31st of 2015. Yes. I had slept at the Serenity House homeless shelter that night. I was on the bus that morning. I was at the Hagens at 9 p.m. I was in this library all day, New Year's Eve 2015. I left the library, right. I went to the Goodwill and the Safeway, yes. Then I went to an Oxford House dance that evening. Now, you as a county have just said in the newspaper that you're obligated. And for some, well, you've made me have to go through over 3 years of pain and suffering because of your bill. Nichols, it was quoted as saying, was obligated to issue the January 25th notice under the U.S. Supreme Court case Brady versus Maryland. This, I didn't have to experience this. I didn't have to go to court for 16 months. Yes. I didn't have to be arraigned in jail. I didn't have to be on personal recognizance for 16 months. Now, that prosecuting attorney's office doesn't seem to understand the significance of the quote that was in the Peninsula Daily News. I didn't have to do this. There wouldn't have been a dismissal without prejudice. No. There wouldn't have been the defendant is not competent to stand trial. Because as I told you, I wasn't in Sequim. Now, all you had to do was to go to the Clallam Transit Center, right? The actual county bus company, yes. And you could have seen I was on the bus that morning. I wasn't in Sequim, Washington at 7:47 a.m. No. See, as I remember it, yes, I was sleeping in the Serenity. I was on bus 26. I was on bus 20. I was at the YMCA. I went to early morning risers. Yes. I got back on bus 20. Yes. Then I was on bus 22. I was at the Hagens at 9 a.m. Now, you made me live through 3 years of torture and torment because you refused to do what is obligated.